Testifying on page 8 of the criminal calendar, Charles Happa.
Ashley Winolly, Deputy Prosecuting Attorney for the state.
Mr. Heppa, please come forward. Mr. Heppa, the last time you were here, you and Mr. Mao Espirito had indicated that you wanted to consolidate your cases.
Yes.
No motion was filed. Is it still your intention to consolidate the cases?
Yes. We filed our motions. We got extra papers that said that it went through the offices over there, so I don't know what's the hold up with that.
There was something filed yesterday, but it wasn't a motion to consolidate.
Do we
Did you file a motion to consolidate?
I have it here.
You can come forward. Please state your name.
Noah K. Masperio.
All right. No motion was filed to consolidate the cases. Is it still your intention to consolidate the two cases?
Yes, sir.
Just for the motions or in their entirety? Do you want to just consolidate them for the hearing today? Or do you want to consolidate them
What do you
for
mean?
the rest of the way out?
For the rest of the way out.
Any objection to the oral motions to consolidate?
Your Honor, I would like to right now hand forward some. There was an error in my Exhibit B. And I'd like
Hang on, we'll get there.
Okay.
Ms. Winolly, any objection to the motion to consolidate?
The state will defer to the court.
All right, I'm going to grant the motion to consolidate the cases. So Mr. Heppa's case, 5 DCW 17-000341. What page is Mr. Mao Espirito on?
He's on page 12, Judge of the criminal.
All right, Mr. Mao Espirito's case, 5 DCW 17-000340. These two matters will be consolidated from this point forward. Couple of things. There's several things on the calendar right now for today. Originally, you filed some documents that the court interpreted or labeled as a motion to dismiss based on jurisdiction. So that's on for hearing today. Additionally, you filed some other documents yesterday. And then today, the prosecutor filed two documents, one against each of you.
Okay.
So, your initial pleading was a motion to dismiss based on jurisdiction.
Yes.
And based on the paperwork submitted, it appeared to the court that the basis was the motion, or for the motion, was a lack of in-person jurisdiction, that the court didn't have jurisdiction over your persons. The prosecutor did respond to that motion. Yesterday you filed about 70 pages of documents, and I did look through them. Hang on, I'll let you have an opportunity to speak. It looked like the documents that were filed yesterday dealt with title to the land.
Yes, Your Honor.
And initially, my implication, when I reviewed it, I thought this may go to the actual trial itself. However, after this morning's hearing, and I do want to note that there was a defendant, Jesse Steele, that appeared this morning. He's charged with a similar offense, or same offense, different property. But I understand you folks are from the same, or claiming the same defense, basically. And he attempted to move to dismiss based on subject matter jurisdiction. So in reviewing your papers that were filed yesterday, are you claiming that the court also lacks subject matter jurisdiction? And I believe what the argument was that was raised this morning is that because this is a trespass case, in order to determine whether somebody is trespassing, title has to be established.
Yes,
and the argument is that district court does not have jurisdiction to determine title. And basically that there's civil statutes to that effect. I'm not saying whether that's correct or not, but I'm asking you, is that what your motion or your papers that were filed yesterday
Yeah,
were?
that's why it was concerning the title and civil matters
Okay.
of the case also.
So, because you filed that yesterday, I want to give the state an opportunity to file a written response.
Okay, so we'll wait.
All right, so I'm going to continue the motion that is on for today, the motion to dismiss based on lack of jurisdiction, so that the prosecutor can file a response. Ms. Uwanuli, did you receive the documents that were filed yesterday?
I only received the document for Mr. Noah Mao Espiritu. I did not receive one for Mr. Charles Hepa.
All right, Mr. Hepa, are you joining in the documents that were filed by Mr. Mao Espiritu?
Yes.
All right, so those documents will apply to both defendants since the case is consolidated.
With regards to consolidation of the case, does that mean one of the cases is going to, everything's going to be under one case number, or are we still doing separate case numbers?
I believe they'll put both case numbers on one document.
I don't think that's possible.
Oh, okay. We'll consolidate it under one document. All right. So for filing, you can put both case numbers on the documents.
Okay.
File one in one case and one in the other, but they get both numbered. Do you have an address to serve the defendants with your responses?
I have been, Mr. Mao Espiritu asked that his documents be served by email and also by pickup at our office, which he has done. Mr. Hepa informed me that he would like to pick it up in person as well. He did not provide an email, but his documents were still in the office when I left on Tuesday.
Mr. Mao Espiritu, is that correct? You're okay with notification via email and you will pick up the documents? I want to make sure whatever's filed by the state is served on you.
Yeah, I will be getting them either through email or physical delivery. I'll go over and grab them.
All right, Mr. Hepa, I understand you want to pick yours up in person.
Yes.
The question is, how do they notify you that they have something for you to pick up?
They can call and contact Noah
Sure. Email.
or email Noah. And
All right, so you're,
same thing.
You are accepting service through email?
If you can, email both of us, please.
But
Well, if you give
That's-
us your email address, then they'll notify both of you if they have two email addresses.
the state was actually only given
Okay.
Mr. Mao
Yeah,
Espiritu's
Just hang
email.
on, everybody talk one at a time.
Sorry, Your Honor, the state only has Mr. Mao Espiritu's email. That was the only one. If that's the email to also email Mr. Hepa, the state will be more than happy to use that email.
Or do you have your own email, Mr. Hepa, that you want them to serve you?
I want them to send it to Noah's email.
That's okay with
All
me.
right, then that's how service will be done.
Okay.
So I'm going to continue the motion on today so that the state can respond. Do you understand the nature of their motion, the documents that were filed yesterday?
When I read the motion, it looked like it was something that was happening for the civil court matter, which there is. My understanding is there is a civil court matter that is also happening that is different from this criminal matter here today. And so I
believe
thought,
their argument is, so go ahead.
so I thought it was misfiled possibly in the wrong
That was my
case.
initial response. However, after hearing what Mr. Steele argued this morning, was that we didn't have jurisdiction because we can't determine title. So their argument is district court lacks jurisdiction because title has to be determined in order to determine a trespass. I'm not saying that's correct, I'm saying that's what their argument is. And I want to give you an opportunity to respond to that.
Okay, thank you.
All right? So we'll continue this. I'm not going to be sitting the first 2 weeks of June. So we'll continue the hearing till June 28th at 2 p.m. Miss Wendy, I will give you till June 7th to file your memorandum in response and serve it on the defendants. Mr. Hepa and Mr. Mau Espirito, once you get the response from the state, you can file a supplemental response if you want. It should be filed at least 48 hours before the hearing date though. So everybody has a chance to review it.
Other defendants will be
48 hours.
2 days prior to the hearing, that's all.
June 7th.
Oh yeah, June 7th for the prosecutor. All right, so the motion to dismiss is being continued to that date.
I would like to, there are some errors in my addendum I filed yesterday. I just like hand forward the correct document for Exhibit B to you actually.
All right, you want to, let's have them filed in open court.
There was an error to my, Exhibit B. I forgot to put this in the back, the notarization by the Kalangimoku. One for her and one for him. My original one I filed, I didn't have the back part, so I given you guys the correct copy, one for her and him. Oh, why do you guys need one too? For the...
No, we're good.
Okay.
We can make copies if we have to.
I can make a copy.
All right, now, there is one remaining matter on the calendar, and that is the state has filed against both Mr. Mau Espirito and Mr. Hepa an ex parte motion for an order directing the defendant to stay away from complainant's property. Miss Wenoli, it is ex parte. Have the defendants been served?
Yes, Your Honor, they were served. We had informed, I gave a physical copy to Mr. Mau Espirito yesterday, he was also sent an email as well, letting him know that a hard copy was available for him and that it had an attachment. It had the file copy attached.
Did you receive the copy of the motion?
Yes.
All right. Both of you received a copy. Ms. Wenoli, do you want to add argument to your motion?
No, the state stands on its motion, Your Honor.
First, Mr. Mau Espirito, do you want to respond to the state's motion?
Yes, Your Honor, I would object the ex parte charges because removal of me and my cousin from the property of the rural patent lands would be a criminal government tort and a violation of Geneva 4 under Article 45, 46, 47, 55, 56 of the Hague Relations 1907. That will be a violation on the laws of occupation.
All right.
And, Your Honor, also in that, so we talked about the trespassing on ex parte.
They have filed an
So I
order.
talk about the,
order
Yeah.
asking the court to sign an order
Yeah.
saying you cannot go back to the property.
Yeah.
You need to stay away from the property.
Yeah.
So that's what we're talking about right
okay, and also I object because in order for that would happen, title over the property would have to be confirmed. And once again, like Jesse Seal said earlier, this court is a limited court to decide title issue in Hawaii. So I object to their ex parte against me and my cousin to the properties of Wailua, the rural patent lands.
All right. Anything further?
In concern of ex parte only,
Yes.
like I said, in order for that, for the record, in order to that be legal, we gotta clear up the title issue first in the civil courts, I feel like. Title would have to be, the issue of title would have to be confirmed first before they could ex parte me from a property, because they're already making it a title issue. I filed a claim showing our titles to the interest rights to the title. It's a dispute on title already. And they cannot ex parte me from the property until we finish that dispute of title.
All right. Anything further?
No, Your Honor.
Mr. Hepa, anything you want to add, or do you want to join in Mr. Mau Esperito's argument.
Uli.
All right, Ms. Wellesley, you
Come.
want to okay, go ahead.
Also, can I talk since I represent?
You don't represent him, you represent yourself.
Okay.
You're not an attorney, you
Okay.
can't represent.
Also,
another
since,
person.
for the contract, for the title thing be cleared, first of all, State of Hawaii would have to show on Treaty of Annexation, clear title to the lands and a contract with the Hawaiian people in order for the title thing to be even brought up. And until they bring that, I object to the ex parte from the property. Because title is an issue because no more Treaty of Annexation, contract with the Hawaiian people, and clear title to the lands in Wailua. That is rural patent lands. And is already confirmed by Econs Mahoe, State of Hawaii abstractor, that rural patent lands are for the Hawaiian people and there is no adversity of rural patent land commission award lands. If the heirs do not show up to court, Econs Mahoe stated that the lands immediately revert back to the original Aupua of the original Hawaiian of the Aupua. And the State of Hawaii or Tyler Green or the county is not the original Hawaiian of the Aupua. So the rural patent lands, LCA lands, cannot be bought or sold legally, according to Econs Mahoe's statement, who is the abstractor for the State of Hawaii. And I filed that in my attachment addendum. His
I did
response.
see that in your papers. Ms. Wellesley? Any response?
The state would stress that according to the tax map key, which is maintained by the state of Hawaii and the county of Hawaii, it does list that the properties are owned currently by the Cocoa Palms Hui LLC, and according to the Department of Commerce and Consumer Affairs, the business registration division, it does list Mr. Waters and Mr. Chad Waters and Mr. Tyler Green as managers of that LLC. It does not list the defendants as title holders according to the key map, the tax map key.
Ms. Wellesley, first of all, tax map keys are not very accurate and current. There are transactions that occur and they're not updated immediately. Commerce and Consumer Affairs basically it's based on what you file. They'll indicate that. Title report is normally the most accurate way to get title. At least somebody will do an actual title search. Basically we're in a position where you're saying you reviewed something.
Right. The state also.
And you think a certain person has title. They're saying they have title. The charge is trespass. So they're saying their defense is that they have title. I'm not saying they do or they don't. I don't know because I haven't been given enough information one way or another. But you're asking me to make a determination and exclude them from property without the issue actually being resolved. How long does the state believe they've been trespassing?
Based on the police report, Your Honor, the state's understanding is that the defendants have been trespassing since March 11, 2017.
Why hasn't the property owner filed a civil ejectment action? There is a specific cause of action where a property owner can file to eject people that they believe are wrongfully on their property. In an ejectment action, parties are served, there's notice, the case is decided on the merits. This is an ex parte motion, basically trying to circumvent what is there. There is a proper procedure to do it. Basically, you've submitted an affidavit from Mr. Green saying he's the owner of the property, and a declaration from yourself saying I've reviewed documents and they're not the owner. They're submitting documents saying they are the owner, and to some extent, at least they've submitted actual deeds. I'm not saying they are the owners. I'm not making that determination right now. Just saying, that's the issue, I think, in their defense of the trespass claim. So, I'm not going to do an ex parte proceeding that circumvents a civil process that is there that whoever the owner is could avail themselves to. So, based on that, the ex parte motions for an order directing defendants to stay away from complainant's property is denied. Listen, there's no reason for applause. I'm not making a determination that anybody is the owner of the property. What I'm telling the parties is there's not enough information at this point to make that determination. So that will be litigated at another day, on another day.
Yeah, because the auto exhibit B was wrong, so I just replaced that with the auto.
Put this as your exhibit B.
Yeah, because the auto, I forgot to put the back print.
The certifications.
Yeah, I forgot to put that part on the last one.
So I'm just gonna mark it. I can mark the receiver.
Okay, as long as the record is clear.
Will it be accepted?
Yeah, and it'll be uploaded into the electronic filing system. All right, so I believe that concludes all of the matters on the calendar today for you.
Can I speak some more? I've got power.
What do you want to speak about? Because we have nothing more
Okay,
pending for
thank you.
today.
Yeah, thank you.
All right.